Hi, my name is Wendell Norkia and I teach Law of Criminal Procedure at the University of the Western Cape. This video will look at sentencing proceedings in South Africa. So it will look at the trial on sentence and how does a court impose an appropriate sentence. What will the court look at? And which case law is important when a court does such an exercise to impose a sentence in a court of law in South Africa. So first and foremost, we have various theories of punishment. It is usually the one that everybody knows and the community unfortunately always wants is retribution. Looks at what the offender deserves. For example, because the offender has murdered another person, that person must then be sentenced to life. Or in some countries, that person must then be sent or imposed the death penalty. Because that person murdered another person, we also as the state then needs to kill this person. We need to send this person to death. So that is not applicable in South Africa, so that was abolished in 1995 in the State versus Makwanyane case. So in South Africa, our most severe sentence is life imprisonment. This means that the accused can only apply for parole after 25 years imprisonment. This doesn't mean that he will get parole after 25 years, but that he will apply and the parole board will have to decide whether the offender will get parole. To look at the sentencing proceedings, this will of course follow only after a court has convicted an accused for a crime or crimes. This is also called the judgment stage of a trial, and once the court has convicted the accused of a crime, the court will then follow with a sentence. This can be directly after a trial, or it might take a few weeks for the court to deliberate, and the state and the defense attorney will also lead evidence as to why the accused should receive a severe sentence or a lesser severe sentence. It depends on which party you are representing. So when we deal with sentencing proceedings, we have to look at the factors that a court will consider when granting or imposing a sentence. These factors are in our law since the 1970s, and they are known as the triad of Zinn, because in the Zinn case, the appellate division at the time looked at 3 factors that a court will consider when imposing a sentence. These factors look at the crime that the offender has committed. It looks at the offender as a person in terms of who are we sentencing? Who is the offender? Who is this person we are sentencing? And then thirdly, the court will also look at the interests of the society. This was further developed, these 3 factors were further developed in State versus Rabi, and in this case the court also added a 4th factor or 4th consideration, namely mercy. But the court also phrased these factors differently by stating that if or when a court imposes a sentence, that sentence must fit the offender, the sentence must fit the crime, and the sentence must fit the interests of the society. The victim's interest is also included in the interests of the society. And then Rabi goes further by stating that it is also important for a court to show mercy or clemency when they impose a sentence. So those are the factors that a court will look at when imposing a sentence on an offender. Those 3 factors are important, and then Rabi also added a measure of mercy that a court will consider. What's really important also when a court will look at sentencing, especially with serious crimes, and this only happens in our regional courts and our high courts, not in our district courts, is that the court must consider the Criminal Law Amendment Act and specifically Section 51 of this Act, because Section 51 deals with the minimum sentencing legislation, which has been in our law in South Africa since the late 1990s. This is when the legislator decided that we need to guide judges as to certain offenses and certain punishments that needs to be connected to these crimes. So for some of these crimes that are included in Section 51 of the Criminal Law Amendment Act, you have life imprisonment. For example, premeditated murder carries a minimum sentence of life imprisonment. This means that once an offender has been convicted of premeditated murder, that means a murder has been planned, and perhaps also the offender has destroyed the body, concealed evidence, etc. The court has to, as a minimum, it has to impose life imprisonment. That's regulated by the Criminal Law Amendment Act. However, there's a safeguard built into Section 51, and it reads as follows, or it states as follows. A court can deviate from this minimum sentence, meaning a court can give a lesser sentence, but only if there are substantive and compelling reasons to give a lower sentence. So what will a lower sentence, for example, be for life imprisonment? It could be 25 years direct imprisonment. It could be 50 years direct imprisonment. This means that the accused offender can actually apply for bail probably after 10 or 15 years serving that sentence. So it's immediately lower than a life imprisonment sentence where you can only apply for parole after 25 years. So this will only happen if the court believes that there are substantive and compelling reasons to deviate. Now, what are these substantive and compelling reasons for a court to give a lower sentence than the prescribed one in the Act? These are known very generally as mitigating factors. So, for example, if the accused offender has written an apology to the family of the deceased, for example, if the offender is 19 years old or 20 years old at the time of the commission of the crime, if the offender has a disease currently when he is sentenced, or if the offender is a sole breadwinner or sole parent and looking after his 2-year-old or 3-year-old child. These are all mitigating factors that count in the favor of the offender and which a court will consider when they look at the imposition of a lesser sentence, when they deal with Section 51 of the Criminal Law Amendment Act. Now, generally, in our courts, let's say in a district court, the court will not look at Section 51. Let's say it's a crime of theft, and the court will mainly look at the 3 factors in Rabi and Zin, and then the court will also generally look at mitigating and aggravating factors. Mitigating factors are those factors which will reduce your sentence and will obviously be raised by your defense attorney as the offender. These factors, as I already mentioned, are factors like youth, or factors like you having a small child at home which you need to care for, etc. These factors will automatically reduce your sentence, of course, at the discretion of the court and the judge, but it will not be raised by the state because there are mitigating factors. Aggravating factors will be raised by the state because these factors will or can increase your sentence. These are factors such as lack of remorse. For example, the accused during the entire trial was laughing at the family of the deceased, did not respect the court, and, for example, committed a very severe crime, murdered multiple people, etc. So these are just some of the aggravating factors that can be raised by the state. So that's basically, in a nutshell, what the sentencing proceedings are like and what various parties can raise. And then it is then up to the court to decide what is an appropriate sentence. Of course, a court has a discretion, but they are limited to Section 51. They must first look at what Section 51 states. What is the minimum sentence for the specific crime? And like I said, minimum sentences will only apply to more serious crimes. And if you have a look at Section 51, you will see a list of crimes there, and you will also see the type of sentences that are listed under these crimes. So that is basically what sentencing proceedings are like. The judge will, at the end, or the presiding or the magistrate will decide what the appropriate sentence is, and the offender will receive the sentence when the court reads out the sentencing judgment. And this is, of course, then a very lonely journey for the offender, and it must be a very hard feeling or hard moment for the offender to hear that he's going to receive a life imprisonment sentence, or he's going to receive 20 years direct imprisonment. And from that moment, of course, we hope that the rehabilitation journey starts. And once the rehabilitation journey starts in prison, we also then hope that the offender is successfully reintegrated back into the society when that offender has served his sentence, or part of his sentence if his parole application is successful. So that is basically how sentencing proceedings work in courts. Of course, the judges will also have a look at the types of sentences that can be imposed. Let's say it's in a lower court, and if it's going to be 5 years direct imprisonment, if it's going to be 10 years direct imprisonment, sometimes an offender can be declared a dangerous criminal in terms of Section 276 of the Criminal Procedure Act. An offender can also be declared a habitual criminal if he commits, for example, theft 4 times in a row. So you have various forms of imprisonment that can be imposed by the court. And then you also have forms of sentences that can be imposed. And these are your fines, your commitment or your committal to a treatment center if you have issues with alcohol or substance abuse. And you can also be sentenced to correctional supervision. This will be house arrest or community service. And then you also have the sentence of imprisonment. You also have a compensation order where you will be ordered by the court to pay a certain amount of money to the victim, not to the state. A fine is the money paid to the state. So that is in a nutshell what sentencing proceedings are like in South Africa, and I hope this has helped you to better understand this part of our criminal procedure. Thank you.